that guidance to something that's concrete around consumer harm. And I think that that balance between having something very specific but not fully codified into law and having an enforcement authority to actually address real consumer injury, I think those two things pair very well together. The FTC has done a good job in very complicated spaces like privacy and for a long time in the competition space. Ossifying that, I think, to use a term that Aaron uses in his article, ossifying those types of guidance into rules that are not flexible and which will shape, don't even give people a chance to say, hey, actually, let's redo the cost-benefit analysis before you find me liable for something, I think is very restrictive. So we have a lot of options. It's not just do nothing or have legislation or even have a regulation that comes out of the agency. There's a lot of options that mix the current FTC's authority in a way that I think could add guidance while preserving some of the best things about the FTC's enforcement-driven approach.
And if I could add one point to that, I think it's really worth considering the Obama administration's approach to this problem. If you look at the privacy white paper that the Obama administration issued, it addresses exactly this question. And it says that we don't trust that the government is able to develop solutions that will keep pace with technological change. And so their proposed answer was to rely on multi-stakeholder processes to allow these answers to work themselves through in particular contexts, such that industry sectors would come up with rules and that they would work themselves out, and that the administration would play a convening role, and that the FTC's role would be to enforce those rules. Now, that's not a new idea. If that sounds familiar, right, that was roughly the idea of the National Industrial Recovery Act, with the difference being, on some level, what the government's role was, right? So in the New Deal era, the idea was that the government, in a truly corporatist fashion, really convened and forced and coerced agreement, and that the agreement that was reached was not really bottom-up. That was the Italian model that inspired the New Dealers. In the Obama administration version of this, I sat through many of these multi-stakeholder processes. It was not, I would not say it was coercive, and for that reason, it was, in many cases, was not successful. But it did in some cases reach some agreement on very hard topics, like facial recognition, for example, what to do about that. And at least it helped to define what the problems were and informed, even if there was no workable, enforceable code that came out of it. I think each of those processes significantly advanced the understanding of the issue, and they did exactly the same kind of thing in that sense that the Magnuson-Moss process is designed to do, right? The hearings that Mag-Moss intends to examine issues and to make sure that all stakeholders are represented are just a highly structured version of what the Obama administration was trying to do in a more freewheeling way. And I'm not saying what the right answer is, but the fact that each of these problems keeps dealing with the same, each of these approaches keeps dealing with the same problem, really tells you that this problem is not going away. It's the same problem that the negotiated rulemaking statute tried to deal with in the first Bush administration, right? And the problem is only growing greater now that technology is changing faster and faster. And I don't know what the answer is given the institutional framework we have, except I know what the default is, which is that as each of these ideas fail, the Federal Trade Commission will be left doing what it has done for a very long time, which is using deception to address most of these problems, which is, companies come up with codes. This is more on the consumer protection side, but it may be true on some issues that are thought of as competition issues. Companies come up with their own codes of conduct, and they are held to those codes of conduct in ways that sometimes might surprise them, as in data security, where promising to act reasonably ends up being subject to a great deal of enforcement by the agency. And that's the default against which all of this is really operating, and of course the antitrust laws.
Thank you, Berin. When talking about rules, we obviously have the per se rule against, horizontal price fixing that was discussed, of course, earlier today. Then there is, of course, the price, cost, and recoupment rule for evaluating, predatory pricing claims. But I was wondering, could rulemaking facilitate beneficial procedural reforms by structuring the rule of reason in potentially helpful ways? And Koren, I think you have been doing some thinking and writing in that regard. And I think you also referred to is there any record in that regard that, for example, when it comes to the harm from things like non-competes and exclusive dealing, which should be really required as a prerequisite for any kind of thinking in this regard on rulemaking, could you share your thoughts on that?
Sure. So when I think of rules, I think of more, you can't have emissions above a certain level, or you should do this, you should disclose, X to so-and-so. Something that is really clear and you go out and you do, and is, able to be sort of monitored and easily complied with. The idea that you would use rulemaking to shift burdens, just to say, we're still going to do analysis, it's still going to be time consuming, and we're still going to dig into the economics, but we're making it a little easier for us. We're going to sort of usurp the democratic process because we can't get it done in Congress, so we'll just do it in rulemaking, and we'll, kind of overturn the Supreme Court. Troubles me, as you could tell by my tone. But I also don't think it achieves those goals that we talked about in the beginning, right? Of clarity, or of judicial or agency economy, things like that. I think that, again, as I mentioned before, all antitrust is effects based. It's just a matter of what kind of effects. Is it a structured or unstructured rule of reason? And it's all, comes down to error cost rules, right? And so there are some kinds of conduct like price fixing that are not always harmful, but we say, well, pretty much a lot, generally they are, the majority of the time. So for error cost reasons, we're going to create a per se rule. And the idea that, that you need a record, Krisztian's question, there's a robust body of empirical literature that indicates that vertical restraints are generally pro-competitive or benign. And this is a bipartisan kind of group of, from Francine LaFontaine and Slade to Cooper and O'Brien, to others, and they're really, meta-studies looking at a lot of individual studies. There's been criticism as of late, but a lot of the criticisms are really theory papers. And, don't get me wrong, theory is very important, but theory doesn't tell us whether we have a systematic under-enforcement problem and harm to consumers or competition, right? It just tells you what could be. Coming back to Krisztian's question earlier, which I didn't answer before about type 1 and type 2 errors, I think that's fundamentally what a lot of this debate is about, right? Whether you're more worried about intervening when you shouldn't or not intervening when you should, whether you trust that markets will self-correct over time, and whether you trust the government to intervene in a wise way, especially like in nascent or potential comp cases where there's a lot of crystal balling going on, right? So I think that for me, I agree with the Supreme Court. I'm much more worried about type 1 errors. I do believe that the market can self-correct over time, whereas if you intervene when you shouldn't, it has a chilling effect. But I don't have empirical evidence, right? It's a prior. But the thing I would say is that if it were true that we have a type 2 error problem, I would expect that to show up more systematically in the retrospectives. And I am just not seeing it. So I'll stop there.
Yeah, Berin, any follow-up comments on this?
So I'll just, people have talked a lot about type 1 and type 2 errors, and I think it's easy I think economists talk about these as if, the math is essentially just add them together and see how you minimize it, right? When you're talking about government intervention, though, the lawyer in me says there should be a default against, there should be a prior against government intervention, and therefore you should err on one side over the other. And so I just wanted to raise that because I think where the economic question is right, I think And you could even try to tackle and answer that question, why systematically do we think we should have a premise against government intervention or have the burden be on the government to intervene? We could take a law and economics approach to that, but just general, I think we shouldn't aim for them to be equally balanced. I think there should be a default in one direction.
Thank you. So there was a lot of discussion today about the FTC's UDEP and UMC rulemaking authority. As we've heard, really, most commentators, seem to think strongly that petroleum refiners and that mode of statutory analysis from that particular case would really not withstand scrutiny under current textualist standards, in particular in light of last year's AMG Capital case and decision. So I'm turning to each of you, perhaps starting with you, Neil. Kind of like, what are your views on the agency's authority to bring UMC rules in light of current case law? And then I would love to hear from our other panelists as well on this.
So I'll just give a summary of what happened earlier today, for the most part. I mean, I don't think I can add really too much to what people like Dick Pierce and Maureen Olhausen say on this point. I actually took both admin law and antitrust law from Professor Pierce. So I'm not really going to be able to say it better than him, and what he essentially said was petroleum refiners was decided in a way that nobody on the Supreme Court today would use that type of statutory interpretation, which was essentially, and Berin wrote a whole chapter of the book on this, so he's going to say it much better than me, and maybe I should just shut up, but I won't. Essentially that rulemaking authority would make the agency more effective in what Congress wanted the agency to do, and therefore the agency has that authority. That's a way oversimplification, but that's sort of what they said. And that would not fly today at this Supreme Court, I don't think, with any justice currently in place. Furthermore, it was a DC Circuit position, and it's never been embraced by the Supreme Court, that approach. And so I don't think under petroleum refiners the FTC has the authority to do this. I'm much less familiar with the Rule 18 argument, but I'll let others tackle that.
Thank you. Berin, for those who haven't had a chance to review your article in the book yet.
Well, one of several, and I won't repeat too much of what's been said earlier today. One thing that hasn't been talked about is what the litigation will look like or how it will unfold. So let me start there. So I think that the Commission is in a very difficult position, given how long it's taken to get to full staffing of getting 3 votes. Now that they have it, they have time to do, I think, 1 round of rulemaking and to start the litigation. They don't have time to do a rulemaking, do the litigation, and then see how it goes, and then from there decide whether they're going to do more rulemakings. And this is, in some ways, the most unfortunate thing about this situation, because what it means in practical terms, given the enormous pressure upon the agency to do something here, is that the chair is facing enormous pressure to launch multiple rulemakings on this untested legal theory, or a theory that is upheld only by this one decision. And I fear that what she will end up doing is launching a bevy of rulemakings and then losing on all of them and finding that she's wasted the time not just of one small team of people working on one rulemaking, but of a large percentage of the staff. I think that's very likely. And one important detail, we've heard a little about whether challenges could be brought pre-enforcement and so on. The one thing that is very clear is that no challenge could be brought until the rulemaking has been completed and there is a final agency action. So we have to wait for the Commission to complete at least one of these rulemakings. And as I said, they will probably do them in parallel. So that's what I think is going to happen procedurally. And I think when this goes up to the DC Circuit or whatever court it goes up to, I think the argument will be laughed out of court. And we explain in great detail why, if you want one thing to supplement this book, I would highly recommend the excellent article that Professor Tom Merrill and Catherine Watts wrote, Agency Rules with the Force of Law. It's mentioned in our article and all the other articles about, all the other chapters about this topic. But they explain really beautifully that in the progressive era and really up until some point close to or around the Second World War, Congress followed a very clear convention. which is that you will find this language about making rules to implement or give effect to or whatever a statute. And the meaning of that language, and however it was worded, depends on one critical question, which is whether the Congress was explicit in giving the agency authority to impose some kind of penalty, whether that's financial or the loss of license or something else for violating regulations. They document this very thoroughly. And if there's one thing missing in the Federal Trade Commission Act, it's that. And even more than that, the Federal Trade Commission Act in its original form doesn't even have any provision for penalties of any kind for violations of the act itself. So to think that this is somehow consistent with that convention is simply crazy. But we note in our article that there are many other ways to see that this is what Congress intended, that 6G is used for making procedural or interpretive rules, and some of them have already been discussed, so I won't dwell on the points about structure. But I would just briefly note that we haven't talked much today about the non-delegation doctrine, but in our chapter we explain two ways in which the non-delegation doctrine requires the conclusion that 6G does not grant the agency substantive rulemaking authority. One is that that's clearly how the court is heading towards interpreting the non-delegation doctrine, that if you look at Gundy, for example, that would have been a majority opinion had it not been for the very unusual configuration of the court at that point. And while there might be a delegation problem with Section 5 as it is, that problem is clearly heightened if the Commission has the ability to make rules interpreting Section 5 as the basis for deciding what is unfair. But even more than that, as I said in the question I asked to the earlier panel, when courts today look at ambiguous statutes, they ask themselves, what would a reasonable person have understood by the words in the statute at the time? And it is very clear in 1914 that non-delegation was very rigidly adhered to. And we document in a number of very recent Supreme Court cases, including cases immediately prior to the FTC Act being enacted, that Congress, in fact, was adhering quite rigidly to that conception of non-delegation. And if you fast forward to Humphrey's Executor, whatever you think about that decision, whether it was rightly decided or not, the court in Humphrey's Executor specifically notes that the agency had this, what it called a quasi-legislative function. And it talked about it essentially in terms of what we now would recognize as non-delegation. In other words, it said that the Commission operates doing adjudication, and then it has this quasi-legislative role of writing reports, right? If the agency had been understood in 1914 or fast forward to the 1930s to have the power to issue substantive rules, surely the Supreme Court would have noticed that in Humphrey's Executor and would have said something about it. So those are some of the reasons. We also note that the FTC Act was already pushing the boundaries on what the Supreme Court was going to allow at the time, in particular the removal power. This is the first time that the Congress had created such a statute where commissioners could not be removed easily. And if you combine all these things together, we say in our chapter that what you see is that to understand the FTC Act, understand 6G as implying a power to make substantive rules, would truly have been a constitutional revolution. It would have been to create a second national legislature with junior varsity legislators who were not removable by the president. And that is simply implausible. And I think that's what the courts will say today, which is why I say that ultimately when this is litigated, this will be laughed out of court. And what the agency may find is that they've teed up non-delegation questions, not just about the rulemaking power, but about Section 5 itself in the worst possible way. So they could really wind up losing not just this theoretical power that they claim under 6G, but they could wind up with a decision that really clips their wings about Section 5 or really forces Congress to rethink how the FTC works across the board.
Thank you, Berin. Koren, did you want to add anything on this? Or good. Then perhaps, we are turning kind of like to really our core like of our discussion today, which is really the potential UMC's rulemaking impact on business. And in that regard, I think a couple of times it was mentioned before some historical examples that we've seen with regard to kind of like rulemaking in the competition area. And then, perhaps I'm turning back to you, Berin, first. And I think you also referred to some historical examples in that regard. So I was wondering kind of like what they tell us about competition regulation. And for example, the ICC and the CAB examples in the transportation sector, of course, the National Industry Recovery Act with the NRA, and of course, its industrial codes in the 1930s. There was also the surge, as you mentioned, in the FTC UDAP rulemaking in the 1970s. I was wondering what lessons we learned from these historic examples, and most importantly, what is their relevance to businesses today?
Well, I would just start by noting, as Commissioner Phillips has, that the term unfair methods of competition is, as he said, almost the exact same wording as codes of fair competition, which was the term that was struck down under the non-delegation doctrine in Schechter Poultry. So this is not a hypothetical comparison. The Supreme Court, that's the standing implementation of the non-delegation doctrine. We're heading for something very similar. And so one way to answer your question is we've seen this before. Congress tried to essentially delegate this sort of lawmaking power to private bodies in that case, and that power was struck down. I think we'll see the same result here under the non-delegation doctrine as the court has been heading towards applying it. But I think you asked about business impact. I think you wind up with the same sort of business uncertainty that you would have had in the 1970s during Michael Perchuk's rulemaking spree, where every business in America knew that the commission could come after them and make some rule governing how funeral homes marketed caskets, or labor practices, or pollution, or anything else. I mean, once you make everything fair game for an agency to regulate, you wind up with what Neil described, where the agency becomes a super legislator. I mean, I'm like Neil, a communications lawyer. And the FCC has long been described as the junior varsity Congress. And it's exactly what Neil described. You get lobbyists going in to lobby the commissioners, who are, they're essentially 5 legislators, and they get to make value judgments on behalf of America, right? That's precisely what Justice Gorsuch was getting at in his dissent, or his opinion in Gundy, saying that the non-delegation doctrine should not allow, right? What he said was not that we should strike down the entire administrative state, not that administrative agencies should never have any power to make rules, but that the policy decisions, the value judgments, have to be made by Congress. And maybe something like Section 5N, which defines unfairness and says that you have to go through this balancing test, maybe that's adequate. I don't know, we'll see. But I think it solves a problem that businesses face by not knowing how answers are going to be arrived at. And I think it's that sort of meta uncertainty that is most problematic. This question has come up a few times today about what is it that's so problematic about unfair methods of competition, right? It's precisely that it lacks not just clarity as to what is unfair in each case, but even as to how you would arrive at that answer. That's exactly the problem that Congress in 1994 tried to solve by defining what unfairness means in the context of unfair and deceptive acts and practices. And we don't have that today. We don't have it for several reasons, but one of them is that unfairness is even more amorphous in that context. So this is just another way of repeating what we've already said before, that the problem here is that unfairness is so uniquely murky. The commission has such incredibly broad jurisdiction. And when you put those two things together, you could see a repeat of the 1970s experience, but even more aggressive, where then it was sugared cereal and children, funeral home practices, et cetera, et cetera. And today, what couldn't it be? What isn't potentially an unfair method of competition?
Thank you for that historical perspective, Berin. Next, I'm turning to Neil, and I also wanted to follow up on the discussion on the cost-benefit analysis that was also the topic of the previous panel. And I was wondering if you have any comments on this issue, Neil. In particular, how do you see the trade-offs between competition enforcement and rulemaking for business? And that would include particular sectors or specific sectors. I think you would have some comments perhaps on technology, of course, but any other sectors as well.
Yeah, sure. Before I get to that,
Sure,
just
if you have any
a response to Berin. One thing that's particularly interesting in that space is unfairness is very vague. Unfair methods of competition is pretty vague, but at least it's tied currently to consumer welfare. The existing administration also wants to bring in lots of other factors, and so that just muddies it up even more so. If you think about a rule at the FTC that looks not just at the effect on competition or on consumers or competition, but also maybe on labor markets or diversity or environmental effect or any number of factors that some people have advocated that the commission should take into account when applying the antitrust laws, you end up with an even more murky both outcome and process than we've had.
And if I may briefly, that's precisely what Michael Perchuk said in the 1970s. He would go around giving speeches talking about what about labor, what about the environment.
Yeah. So to the effect on specific industries, I did mention, and my chapter focuses on the potential effects in technology and innovation. And they're framed around those four factors that I mentioned earlier, the four weaknesses of rulemaking, all of which are exacerbated, I think, in the tech sector because of the speed of technology in that space. I'll just give some concrete evidence of the speed of the increasing speed of technology. I think we all sort of have an intuition around it, but it took the telephone it took 39 years for the telephone to go from 10% adoption to 40% adoption. It took 3.5 years for social media to go from 10% adoption to 40% adoption. So that's the magnitude of change. That's a single administration, right? And so regulators have a really tough time keeping up with even what the current business models are. And when you're writing rules, that's very, very challenging. A rulemaking process at a regular agency using APA can be a year-long process. I think that's pretty normal. And it's even more challenging, I think, under some of the MAGMOS restrictions at the FTC. And so making rules, even if you could get the knowledge that you need to make the rules in the first place, making rules that aren't out of date the day they go into effect is very, very challenging. Which is why I think you would expect, I was talking about this afterward previously, you would expect you would immediately see a flood of the big players in the tech space into the agencies to try to shape the rules in a way that matches their business models. I think we've seen this to some effect in Europe. And so something like the GDPR, which there's been good empirical studies now showing that the market share of the biggest advertiser networks in Europe have gone up because of this rule. And so I think that you could expect the same sort of unintended consequences on competition from a rulemaking process rather than a consistent enforcement of a consumer-focused antitrust approach. And so, again, I think that's particularly exacerbated in fast-moving industries like tech, but it probably applies across the board. I mean, the FCC is a really good example of an agency that repeatedly has stopped the disruptive competitor from competing with the incumbents, largely at the behest of the incumbents. That is something that can only be done when you have rulemaking power. It's much harder to do that case by case. And so I really worry about turning the FTC into the FCC under this approach.
Any comments on this from our panelists, or shall we continue? Yeah, so next, I thought it would be important for us to discuss, even if the commission would then have this UMC rulemaking authority, what would those rules actually look like? What would competition rules look like under this authority? But importantly, does the FTC actually have any practical ability to enforce And I think one thing that came up perhaps during some of the earlier discussions as well, even if the agency would enforce these rules, then they can only say stop, and only after saying stop and violation of an order can they seek penalties. I think it also came up as part of some of the other discussions on kind of like limited or very limited remedies. And I wanted to see if you have any thoughts on that. Perhaps Koren first.
Sure. So I think that's, part of the problem is I don't think we have a lot of clarity on what the FTC wants the rules to say. Maybe non-competes would be along the lines I described earlier, but the suggestions that we would have it for things like exclusive dealing, or the consultation also suggests looking at other sort of unfair kind of terms. And so, but I do think that, like I mentioned before, there would presumably need to be some sort of market power or share screen, and some sort of affirmative defense for when it's legitimate or necessary. I can't imagine you just, completely ban all ubiquitous conduct, even this FTC. But, some of the things I think, in addition, I could see some of the recommendations that were in the House Judiciary Committee Majority Staff Report, which Chair Khan, when she was then on the Hill, was the primary author of. And those were things that actually, some of them were per se. So some of them were per se legality for tying or certain types of bundling by firms with market power, getting rid of the recruitment requirement for predatory pricing, getting rid of any requirement to show a prior profitable course of dealing for refusals to deal, and basically overturning Amex. So if they're going to do a slew of rules, sort of these are, I could imagine these also, coming into play, although they haven't been put up for consultation. So here's the thing: I don't think the FTC has the authority, and I don't think there's a record of harm to justify rulemaking. But at the very least, if you're going to do it, go hire some experts who know how to write rules, right? Hire people. Tim Mears did this when he was, came in and was moving away from rulemaking and decided to, wanted to go more by case adjudication. He brought in expert litigators and people that he knew were experts and could lead in those areas. The other thing about the enforcement is, agencies with real rulemaking authority have the ability to impose penalties. And so I don't think there's any practical way to enforce when you don't. Right? I mean, as Berin said, the FTC doesn't even have the authority. There's not even a penalty for just violating the act. It's violating an order. So, without those penalties, I don't see there's a practical way to enforce it.
Any other thoughts or comments also on litigation potentially?
One comment on this: I know on an earlier panel raised the enforcement point, and the claim was essentially that if you can't, what effect will it have if you can't actually enforce it? And I would say, a little bit against interest. I mean, rules do have an effect on business behavior because no business wants to be caught in the crosshairs. And so businesses, even if they don't see the full, they're conservative in this measure, right? They'll make decisions about how they structure their business and their business models to try to minimize the risk. And an existing rule raises the risk, even if it's not clear of the authority of the agency or the what the penalty will be if they're found violating it. So that's a reason for caution, I think, really, because it's totally possible that a relatively narrow, relatively innocuous rule goes unchallenged for a long time. I don't know that that's going to happen here, but it's happened at the FTC. The FTC has been very good at this, right? Especially not so much in the rulemaking space, but in bringing new cases that are just incremental changes of applications of previous cases to new situations. And over time, if you pick your defendants right, and you don't offer, you gauge the penalties properly, you can end up settling a lot of cases, without ever showing up in court and finding out whether or not you actually have the authority. So I worry about that in this context as well. The smart thing to do, again, I think for this agency would be to do something small and incremental. I don't think that that's going to satisfy any of their political pressures, but so I don't think that that's super likely. But if they were trying to build on the FTC's past track record of incremental approaches to somewhat uncertain authority, I think that's what they would do.
And the roadmap for that is the agency's handling of privacy and data security, where the agency has gone for, at this point, we're going on 20 years of the agency creating de facto law in regulating privacy and data security with no authority. I mean, they asked for it from Congress. They didn't get it. And they've managed to build a kind of, what would you say, hapdash form of law?
I would say a sort of FTC common law.
Well, it's a quasi-common law of settlements, right? And companies will settle with them in ways that have essentially quasi-legislative effect, that create a body of rules, because, as Neil noted, companies don't want to be seen as violating the law. The PR costs are enormous for companies in this field, especially when the companies are not, extremely generic companies like, say, A&P, but rather companies that are at the center of America's culture wars, right? And then, of course, we've also learned that the process is the punishment, right? So the companies have an incentive to settle, to make things go away. So that would be a smart way to approach this. I don't think that's what they'll do, because they're under too much political pressure. But I will just say one other thing that I think they would do if they were really smart about this. If I were the FTC chairman right now, in addition to making these what are clearly substantive rules about specific policy issues, I would have my general counsel's office look for opportunities to make what are more clearly interpretive rules. I would look for specific provisions of the statute that I could make a rule to define, because I think that the agency does have the authority to do those. You've heard this a few times today. I don't think anybody will actually dispute that question. And that's a detail that gets glossed over when we talk about substantive rules versus, really, it's non-substantive rules, which includes both procedural/housekeeping rules and interpretive rules. And I'll just give you an example of that. The agency is clearly going to be more aggressive in using a provision of the Act that allows them to impose civil penalties upon parties who have notice of past agency orders that are on comparable terms. And the agency's been very aggressive about sending out these letters and then saying, we put you on notice, you know about this, you know about these decisions that we handed down 50 years ago, we think it's similar to your conduct, and if you do this again, we will go after you, we will get monetary penalties. There are several words in the statutory provision at issue that would lend themselves to an interpretive order. So you could imagine that happening. That's what a normal agency would do in a statute that had a lot of words. The problem is that with respect to competition, there just aren't that many words to define, right? You could define some of these procedural terms, but it's hard to see where you would get very far in defining things like this that are purely interpretive and that don't have legislative effect, like defining what constitutes unfair methods of competition. Clearly is something that has legislative effect. It's not merely interpreting words in the statute in order to help you administer the act. But I do think you'll see some of that, and if nothing else, it'll give them something to point to and say that they didn't lose on everything.
So just to clarify my position, I honestly think that in many ways the case-by-case approach that the FTC has worked on in privacy has been pretty good. It's been a good way to continue to expand consumer protection into a space in a way that has been in many ways better than some of the alternatives, right? So big general rules like GDPR that don't really benefit consumers that much, aren't really that tied to protecting them. It has its downsides for sure. And I'll point out one of those downsides I talk at some length in my book chapter. There is a particularly strange settlement that I think has basically gone under the radar for everybody, that the FTC entered with YouTube on COPPA violations. And they essentially changed the rule for YouTube, which they often sort of heighten the standards for a violator in lots of contexts. But in this particular case, it wasn't just the company that was affected. It was hundreds and millions of people who used that service, often for business purposes, and who had no stake in negotiating that particular settlement between the commission and YouTube. And that is a model for regulation that's that's in many ways worse than the commission having to go through a rulemaking under APA or MAGMOS. And so I would, and again, did not get challenged because the parties settled, right? So I don't know where that's going to go. If I was a creative person at the FTC, I would look for more opportunities like that. Thankfully, I'm a creative person outside of the FTC. So maybe they're not listening to this. I don't know.
Looking at the rulemaking process from a business perspective, I was wondering if any of you would have any thoughts on kind of like counseling when it comes to rulemaking and counseling clients in that regard. Participating in the process, engagement, and all of that. Do you have any thoughts on kind of like how to go about that?
Do I want to say this?
You could whisper it to me.
I'll whisper to you, you say it. I'm not sure that they'll be listened to. I think that the agency has a very clear vision, the majority, and they know what they want to do. And one of the hardest things now, speaking on panels or having dialogues, is I feel like I used to think, gosh, maybe I can help, persuade someone at the margins or someone, but I don't. I think there's an idea that if you work for or represent big tech or in certain industries, we're just on different sides, and so I don't know. I feel like if I'm counseling certain companies, it might be yes, have help fund scholars and people that already have views that you can support and help fund research and empirics. But I don't know that certain companies, going to the agencies themselves help. And for companies that aren't sort of big tech targets, it might be good to stay under the radar. So it's sad. I mean, I do like that academics and really smart people are submitting comments and participating, but I'm not sure we're having a real dialogue among the far sides.
So to me, it's particularly challenging at the FTC just because the FTC doesn't do this very often. So how you participate in a rulemaking at the FTC is really unclear, I think, even to practitioners, because the FTC doesn't do it. The FCC, everybody knows how you participate in rulemaking. People have a general sense of like how effective their comments are going to be or not. They know what the process is going to be. Staff knows that if they don't deal with certain things, that it's going to come back in the litigation. Leadership knows that very clearly. I question whether or not the leadership at the agency right now cares much about whether or not they win in court. I think some of this might be, I think they do in the long term, but I think in the short term they're just trying to move the Overton window, and I think they might be very aggressive. And so, but again, it's very hard even to figure out what the mechanics are of participating, other than, we can all sign up and do our grievances at every open meeting. So I guess you could participate in that way.
Well, we can actually all sign up and air our grievances at every open meeting. We get 2 minutes.
That's what I was saying. I participated in the first one. It was very fun.
The difference is really striking. When you contrast the proceedings where the agency has taken input on the two UMC rulemakings that they've proposed, the level of quality of the comments and the number of comments for such an important step that the agency was going to take, it was remarkable how little was said, and in particular how little was said on the underlying legal question. I mean, other than ourselves and Commissioner Olhausen, there were very few people, I think it was maybe 5 comments, that really got into the substance, the underlying substantive question of whether the agency had the legal power to make such rules. If this sort of question arose at the FCC, you'd have dozens of parties who would be going in to comment on that, and those comments would be well lawyered. And it's not that there aren't good lawyers in this field, there are, but they're not in the habit of doing this. As Neil has said, as Koren said, they don't know that it's going to matter. And what we see is the result of that. It does not look like rulemaking at the FCC. I think that Neil's right, that this is in some sense really about theater of a particular kind, which is the goal here is win or lose, they win, because they get to show that there are problems that require a solution in their view, and they'll make that case by using the rulemaking process to essentially draft something that will look a lot like the report that Lena helped to lead when she was working for the House Judiciary Committee, right? Each of these rulemakings can be thought of as essentially producing the same report. And then, oh, by the way, it'll go to the courts, and it may or may not actually withstand legal scrutiny, but what they'll get out of it is a sense of momentum around something that they could then push on the Hill, which may or may not ever actually pass, but at least it gives them something to fight for. And I think it's really sad when I keep coming back to President Wilson's vision. Whatever, I have very few nice things to say about him. This is pretty much the only nice thing. But at least he understood at a time when there were very few experts in Congress, there were no significant committee staffs, there were no congressional advisory agencies like the CRS and the GAO and so on. At least he understood that we needed to have a role for experts to inform the legislative process. And this is kind of the funhouse mirror bizarro version of that, right? It's not being done I think, in good faith. It's not being done by people who really want to actually study a problem and carefully report on it. It's people who have a very clear agenda and want to have the pretense of taking public input. But their idea of that is on the one hand, to cut out at every possible opportunity the input that Congress intended, for example, in the Mag-Moss process, to actually guide the agency. And instead to say, but look, we had open mic night at each of our meetings. People got the opportunity to speak, and therefore this has been democratic and open. As if listening to 60 or second or 2-minute sound bites about a topic could possibly substitute for what the rulemaking process is supposed to provide, which is considered expert analysis that the agency is required by the APA to respond to.
So I just want to be clear. I don't think there's any pretext. I agree with Jim. I think we got true believers here. I don't think that anyone, I mean, look, if you believe we have a concentration problem, monopoly problem, all kinds of problems, good for you for going out and trying to change the world, right? I mean, I believe that existing laws are sufficient and will help promote competition and lower prices and innovation, and I fight for that. So just to be clear, I don't think there's any sort of bad intent or trying to game the system. I think what else are you going to do? If you're a true believer, you got to fight for what you think, try to make a difference in the world, right? I do think that my comment about maybe it doesn't matter, like I used to speak all the time and write papers and I loved it. And I still have fun speaking, but I don't feel like that hope that I might make a difference, as much. And I don't think it's because someone has bad motives. I just think we're so far apart. Like we're reading the same studies and coming to different conclusions, right? Or, it's like that whole body of literature is wrong because there's, one study. And so that's more what I'm saying.
Well, just to clarify what I'm saying, if the commission is sincere about wanting to solve these problems, there's one simple thing they could do, which is for whatever rules they propose, they should also submit a proposal to Congress for what legislation would look like. Right? And I think they owe this to their, if nothing else, to the staff. Because if they don't do this, then every FTC staffer who works on one of these rulemakings is going to spend every day they do it knowing that there's a good chance that they're going to lose and nothing will come of the work that they do. Whereas at least if they provide a recommendation to Congress to say, here we've studied this problem, here is the sort of report that President Wilson would have envisioned that we author, here's what we think the problem looks like, and here's what we think can be done about it. It wouldn't be very difficult. You could take essentially, presumably, you could take the same sort of language that you might put into the proposed rule and send it to Congress and say, look, here's what we think might be an appropriate rule. This is going to be litigated, but you should consider doing this. And I think that they'll find that that will become the only vehicle for doing that. I'm skeptical that Congress will be able to actually legislate, but at least that's the right place to be having these conversations.
Yeah, I'd add to that. I think they could not just submit potential legislation, but they could issue what the FTC has done in the past, reports, summaries of the comments that come in and how they would address them. And even if that's actually my biggest hope is that if the silver lining for even if these rules get struck down, that the commission takes a tack that produces some interim products that are public that at least help advance the discussion. And I think that they could do that. Maybe that has litigation challenges. Maybe it shows their hand when they don't want to. But I hope that they look further past just maximizing their chances in court and look at how they might help shape the discussion by using the soft law methods that the FTC has been very good at in the past of issuing reports, having conferences on topics, convening people, discussing difficult issues. The previous administration did this on over and over and over with a whole bunch of issues that I was quite skeptical that they should be even talking about. But it was very useful in that it raised discussion around some really important issues. And I think this commission should look at what might the interim products be that could be beneficial to their position and not just the final rules that they might put out.
And unfortunately, I think we already know the answer, because one of the changes made to MAGMOS, as Howard mentioned this morning, or is in his chapter, can't recall which, was taking the existing requirement that the commission produce a public version of such a report of all the comments, and instead keeping that document private and confidential to the commission, right? I mean, that suggests that this commission is not interested in doing that thing that President Wilson had in mind, which is, again, I think is unfortunate, because we could actually use more of that analysis precisely for the reason that Koren keeps mentioning. We don't agree about what the facts are. We see that there are studies out there, people debate them. The commission, whether any one particular commission is right or not, at least has an opportunity to say, here's our take on these studies. And then importantly, the two minority commissioners have an opportunity to respond with a minority report to say, well, the commission puts too much weight on this study, we take a different view. And then you could at least create the beginning of a conversation about substance, where the answers might change over time, where the next commission might do something other than simply repealing what the last commission did, and might offer a reasoned analysis responding to the previous analysis, right? That would be an improvement over today, and unfortunately there doesn't seem to be an appetite for that.
Sorry, I feel like this is the Berin and Neil show, so I'll just make one more quick thing. On that point that Berin just made, what's really interesting is the role of a minority commissioner in a situation like this. With a report, the commissioner often gets to help shape the report, but they can also issue something responding to it. Often it's much harder when there's a final rule. This is particularly true when you're bringing cases, but it's much harder when you're just looking at a rule to be able to respond to all of the points that are in there. Sometimes you will get pushback from the GC basically saying like, oh, you can't disclose that, especially if they've set rules up so that some of this stuff is non-public, the discussion. And so I wish that they had not removed that provision. I think, and I hope that they will find a way to at least put out some public documents that reflect the sense of the commission, not just the press release that will accomplish it, accompany the rule, which will only really reflect the view of the chair.
And if I could just say one thing to respond to that. This will sound like a small thing, but it's actually a big thing. The theme that I keep harping on is expertise, right? How do we study topics seriously? And one of the best things about the FTC has been, in my view, the reports where you get not just a dissenting report, which maybe doesn't get read, but you get responses in the footnotes So the commission says something, we think X. And then there's a footnote that says Commissioner Y disagrees, and this is her analysis, right? What that provides is a check, right? You can't depart too far from reality in your report without being called out on it, right? And that's exactly what we want from the commission, is we want both sides of an issue carefully studied. That kind of report is what the commission should be writing. It's what Congress is incapable of doing, and it's what could actually inform a better legislative process.
Thank you for that. I think we have time probably for one or two questions from the audience. If anyone has any questions, Alden?
Thank you, Krisztian. There's been a little bit of discussion of interpretive rules, and people undoubtedly may have forgotten, but the Trump administration took steps to sharply limit interpretive rules. President Trump issued an executive order 13891 that said, yes, non-binding guidance documents are exempt from APA notice and comment, but they've been inappropriately used to compel compliance with the agency's demands. And the order proclaimed the new policy of the federal executive branch was, to the extent consistent with law, to require affected federal agencies to treat such guidance documents as non-binding in law and practice. And moreover, they said if wanted public input, pro and con, in developing new guidance documents. And I know there were some people, my former colleague Paul Larkin, who argued that these are very problematic because they're sort of a hidden type of as suggested, quasi-administrative law that really is unauthorized. So although there's some, earlier today people said some positive things about interpretive rules, I think they can certainly use, shall we say, a sneaky, to maybe better terms, way of trying to influence enforcement policy without the actual authority to do so. At least that was the view of some people in the last administration.
Thank you.
I agree. I mean, that's the point I was trying to make, is that you can call something interpretive that in fact has essentially substantive effect. But then there are other interpretive rules that the Commission clearly could make, and I'm simply just pointing out that A, I think the Commission has the authority to do that, and B, as a political matter, if this chair wanted to wind up with something out of the rulemaking process, she would be well advised by her staff to look for some opportunity to do that, and I identified one. I'm not going to give them advice about what else to do in that category, but I think that's something you should all keep your eye on.
And I would just say, this interpretive rules fall along that spectrum, right, between hard law, the hardest of hard law in legislation, and norms, and they have some benefits and they have some detriments. And so, would I prefer an interpretive rule to what that can be challenged in court to a hard rule that says the same thing that I think is wrong? Yeah, I would actually. So, so that would sort of be my response. They certainly have challenges.
I think we have time for one more question. I see Aurelian, you also have one. Yeah.
Yeah. So I'm hearing a lot of, pessimism about trying to draw a bridge between people who are ideologically just against monopolies and actually wanting to have consumer welfare. I guess probably one area where there might be some chance of having an agreement would be interoperability rules as they apply to mainly digital companies. So things like allowing data to migrate between different tech firms and so on. Obviously, this is something that's going to be a bigger problem for startup companies who are trying to gather data in the first place and don't want to lose that advantage than it is for areas that are already dominated by a few large firms. So I guess the question is, what are the panel's thoughts broadly on maybe reaching some consensus, on a rule that could work for interoperability in digital industries?
I'm not aware of any consensus on that. To me, I think, if you're talking about mandatory interoperability, sort of, requiring companies to design their products in certain ways and share things, I think there's no consensus on this, but maybe I'm misunderstanding what you're saying.
So I do think that people look at this as a possible alternative to antitrust approaches, right? So, but this is a regulatory approach. I think it raises all of the same problems that I I discussed around making rules in the first place, especially the pacing problem. I mean, it's hard for me to imagine that an API designed by the FTC would last long enough. I mean, if it did, it would be because it's essentially mandated to be used. And I find that very unlikely to be beneficial to consumers in the long term. So if you look at competing APIs right now, you know, the history of technology is, I think there's a great XKCD joke where they say, oh, there's 14 competing standards. Let's just come up with a new one and we'll all use it. And then they're like, there's 15 competing standards. I think that is more likely to be the outcome of a interoperability approach, unless it uses the force of government to make companies adopt it. And I doubt that that would be the optimal outcome in the long term for consumers.
All I will say is, you asked earlier, what are the trade-offs and when might rulemaking be appropriate? That is so complicated. There are so many competing interests, and their interests about privacy and security and content moderation, as well as the conflicting economic incentives. That actually strikes me as the kind of thing that is more amenable to being solved in an intelligent way through some kind of multi-stakeholder process, whether that's the kind of multi-stakeholder process that the Obama administration wanted to convene, or potentially the kind of rulemaking that MAG-MOS contemplates, where you essentially draw out all of the perspectives of all the affected parties, because Congress is never going to be able to solve that problem intelligently. And it's also something that's probably not going to be dealt with well on a case-by-case basis. So I could actually see that being, if you were to ask me what is a good candidate for targeted rulemaking authority, I might actually suggest that that's appropriate as a target. The way that I would want to scope it out, though, would be to make sure that you have a process in place that ensures that all of those interests are actually heard. And I'll just say this, at a minimum, if you take nothing else away from this discussion of 6G, that's not the process, the rulemaking process that 6G would give you, right? The 6G rulemaking process, if the agency has that authority, is just the APA informal rulemaking process where the agency goes through the motions of taking comments and responds, but they get to do whatever they want. So if you're concerned with solving problems like that, you need some different process. And again, you have a few models for doing that. Again, there's the negotiated rulemaking process, which I've always wondered why we don't use that more. But that's a problem that's not going to go away anytime soon. And I could at least imagine that what you get out of it is not necessarily a single standard, to Neil's point, that becomes moot, but maybe in a technical sense standard. But maybe what you get out of it is legal standards for deciding how implementation works. And it's not that companies have to design their entire business around someone else, but at least the data formats are such that consumers can export something useful. I would be in favor of that, and I think that's a reasonable conversation to have, but we're not going to have that conversation if the FTC is trying to do this on its own, right? We need the agency to be studying the issue and making recommendations to Congress.
I would much rather solve this problem through CDMA or DMCA reform and allowing adversarial interoperability rather than mandating it.
Thank you for these comments, and also thank you for the questions from the audience. I think we are standing in between you and drinks, and we all know that's never a good spot. So please join me in thanking our panelists. Thank you so much.
Thank you. Thank you very much for this great conversation.